Well, I'm afraid we're having rather a frustrating time with technology today. We'll just go ahead with audio contact with Sir Anthony.
Thank you, my Lord.
Yes, thank you, Lord President.
My Lords, my Lady, before I turn to issue 1, I need to take the board through the prescription provisions themselves, which I don't think you've seen yet, to make a particular point. Your Lordships will, and your Ladyship will be aware of how adverse possession operates in this jurisdiction with respect to unregistered land and registered land. And I need to show you the St Helena position because it is relevantly different. So could I ask you please to turn to page 453 of the bundle. This is Part 9, Prescription of the Registered Land Ordinance.
Yes.
And the point I want to make is that prescription under the Registered Land Ordinance is not the extinguishment by limitation type regime that applies to unregistered land in England and Wales.
No.
Nor is it the same as the adverse possession regime that applies to registered land under the Land Registration Act of 2002. And you will see that under section 135(1), it is the ownership of land that may be acquired by 15 years of peaceable, open and uninterrupted possession.
Yeah.
That is in line with the Roman tradition. Prescription operates to confer rather than to extinguish. And that's confirmed in section 135(2), which refers to a person who claims to have acquired ownership by of land by virtue of subsection 1. And subsection 135(2) entitles the squatter, if I can call them that, to be registered as the proprietor of the land on expiry of the 15-year period. That entitlement is also found over the page in section 137, which sets out the procedure for the application to be registered as the proprietor, and subsection 3 confers the entitlement. I pause there to note that the entitlement under the Registered Land Ordinance is as of right. It is starkly different from the position under the Land Registration Act, where, as the board will well know, if the registered proprietor gives a certain notice, there are only 3 instances in which the squatter can be registered as the proprietor of the land. One is estoppel, one has to do with boundaries, and then there's a third one. The detail of that, if necessary, is in footnote 6 of my written case. It's page 50 of the electronic bundle. But in St Helena, there is an entitlement as of right to be registered as the proprietor. And then finally, the power of the registrar to rectify the register is in section 139(1)(b) at the foot of that page. What then is the effect once the squatter is registered as proprietor? That's set out in section 23, which is on page 419 of the bundle.
Where it says in 139, the registrar may rectify the register.
Yes.
That appears to give the registrar discretion, but is that not in fact the reality?
I couldn't see anywhere in the ordinance any grounds on which the registrar could refuse rectification if the requirements in section 135 were met, were satisfied.
Just en passant, does the argument that you're running in relation to prescription also apply to section 138?
I think it would, my lord. We would say that if an easement could be acquired by prescription, that would also be prejudicing the Crown's title. Can I be more specific? It would apply insofar as my argument depends on section 112. Yep. It may not apply insofar as it depends on section 31 of the Constitution. I'd have to give that some further thought, because that's a different power.
Yeah, no, I was concentrating for a moment on 112.
Yes, thank you.
Yep.
If I can ask the board to turn to page 419. this is the, section 23 is what in the Torrens world might be called the indefeasibility provision.
You need to keep your voice up.
I'm sorry, of course, my lady, thank you. The section 23, page 419, this is the indefeasibility provision, and the board will see that once a person is registered, what is vested in that person is the absolute ownership of that parcel, together with all rights and privileges belonging or appurtenant to it, free from all other interests and claims whatsoever, but subject to two things, namely the things that are registered and the things that are overriding interests by virtue of section 28. And if we can go to section 28.
So presumably the Crown's also not subject to any of A or B either if it's registered as proprietor, if the land was acquired pursuant to section 112 either.
Yes, yes.
I mean, basically, I'm just going to go through every single provision of this Act that might conceivably adversely affect the Crown as registered owner and ask you the same question.
Yes, yes. And there are a few examples of provisions which would prejudice the Crown's title that I can take the board to, but the submission is that the overwhelming majority of the Act would apply without difficulty.
But anywhere that the Crown finds anything it doesn't like or might adversely affect it or prejudice it, in its operation, if it can trace title back to the 1833 Act, it's not affected.
As a matter of principle, that is correct, but I have found 3 instances of things which might be said to prejudice the Crown's title, where the Crown could run that sort of argument. All of the other provisions about recording land boundaries, the provisions that create certainty, the provisions about transmission, how you grant interests in land, the provisions about the registrar, all are beneficial in every sense.
I don't understand. So if the Crown owns the land and it grants a lease of the land
Yes,
for rent,
yes,
and that lease is registered,
yes.
I mean, it must be that the land then, their freehold interest registered on the register is subject to that lease, isn't it?
Yes.
But why do you make that? But do you accept that the interest would be prejudiced by the registration of the lease?
What makes that example different is that the position but for the Registered Land Ordinance is that a lease granted by the Crown would bind its interest. And so the Registered Land Ordinance has merely the same effect, and it does not prejudice the title because the position would be the same without the Registered Land Ordinance. The position with respect to adverse possession, which I will come to, is different because the position under the Registered Land Ordinance is more negative or is worse for the Crown than it would be without the ordinance.
Okay. And were you going to address the position in relation to overriding interest?
Yes. So section 28, which appears over the page, sets out the overriding interests. And there's a couple of points I want to draw to your attention here. The first is, you will see that 28, paragraph 1, subparagraph C, refers to rights of compulsory acquisition, resumption, entry, search, user, or limitation of user conferred by any written law. And H, which my Lord Burrows drew attention to, refers to various other miscellaneous powers of a similar nature. My Lord Burrows raised the question of whether the argument would have the effect of defeating those powers. The answer in my submission is no. Each of the powers referred to in paragraph 1C and the things referred to in paragraph 1H are conferred by any written law. So there will be another law which relates to electricity supply lines or telegraphs or pipelines. That law will apply to Crown land by its own force. The savings clause in section 159 only disapplies, if I can use that word, the Registered Land Ordinance. It says nothing whatsoever about the legislation dealing with electricity supply lines, which confers power on someone to go onto land to install electricity supply lines, or provisions to that effect. So in my submission, there's no inconsistency between our case and the operation of section 28.
So the section 159 only protects you from things that arise from the operation of the ordinance,
Yes.
not from whatever other act there is that says you can fly lines.
Exactly. The opening words, nothing in this ordinance shall prejudice.
So for example, looking at A and B, rights of way, rights of light, air, water and support, those, assuming in St Helena they don't have their origin in a written law,
Yes.
those would not operate against the Crown.
They would, so those must be common law rights.
Yes.
Whatever common law rule gives rise to those rights operates against Crown land like any other land. There is no statutory provision that disapplies them because section 159 is confined to this ordinance. The point I also want to draw your attention to here is paragraph, I've drawn your attention to paragraph C.
Well, I'm sorry, just,
Yes.
just to pursue that. If Crown land is registered,
Yes,
then under section 28(1), registered land is subject to the specified overriding interests. Now, if those overriding interests arise at common law, what then?
if they arise at common law, they are interests to which the Crown land would otherwise be subject. So the day before the Registered Land Ordinance took effect,
Yeah.
Crown land in St Helena was subject to whatever rights relating to light, air, water, and support.
But registered, I mean, the registration scheme is obviously a statutory scheme.
Yes,
And so the whole concept of registered land being subject to overriding interests
yes,
is only created by the ordinance.
yes. The point is that the rights referred to in section 28 are either conferred by the statute, by another statute, or by the common law.
Yeah,
To the extent they're conferred by another statute, it operates
yeah.
Crown land.
Yeah.
To the extent they are given by the common law, it also operates on Crown land.
And well, how do we know that? I mean, how do we know that they are overriding interests? Unless section 28(1) gives them that effect.
I will take a very specific example. So the natural right of air, the natural right of air, that right is an overriding interest and would be given effect as an overriding interest under section 28(1)(b).
But that,
It would not.
but that would be prejudicial to the interests of the Crown.
It would not be disapplied by section 159 for this reason. That right would otherwise bind a common law, so the ordinance does not make the position any more prejudicial to the Crown title
Oh,
than
I
it
see.
otherwise would be.
Right, I follow.
It's a counterfactual question about what the position would be but for the ordinance, because section 159 says nothing in this ordinance shall
Yeah.
prejudice.
Yes, I see. So the statutory scheme is no more prejudicial to
Exactly.
the Crown than the common law was. And so,
Exactly.
yeah, I see.
But was there no prescription before 1980?
I will come to that. If my leadership will bear with me for about 10 minutes, I'll
Yes,
come to that in
please.
some detail. The final point about section 28 is you will see in paragraph F, there's a reference to rights acquired or in the process of being acquired by virtue of any written law relating to the limitation of actions or by prescription. So the point I wish to make there is that a person who is in the process of acquiring ownership by prescription has an overriding interest just as much as a person who has acquired ownership under section 135 has an overriding interest.
So what do you say about the effect of F as against the Crown?
Well, I make the point to illustrate the prejudice against the Crown.
Ah, so F wouldn't operate against the Crown.
F wouldn't, and that is because the position about prescription is materially worse than the position that would otherwise be the case. which I will come to in a moment to respond to Lady.
But I thought you just said that if you had acquired land by prescription before 1980, then you held on to that despite section 159, or are you not saying that?
So before 1980, there wasn't a prescription regime. It was probably, and I'll come to why I say probably, the English adverse possession by extinguishment regime. And my submission ultimately will be, this regime is more prejudicial to Crown title than that regime was, or would have been, and therefore this prejudices the Crown title. The reason it's prejudicial is you're given 15 years under this scheme. Under the regime that would otherwise apply, the Crown has 30 years. I will develop that.
So this is a new argument, I think, is it?
No, this is in our written.
So more prejudicial than the position would otherwise have been at common law?
Yes.
So we have to understand what the law was at common law on prescription, or the equivalent thereof.
You have to understand what the position would be without the Registered Land Ordinance, because in 1980, can I take you to section 159? This goes to my point. It's at page 459.
Sorry,
Yes.
just before we leave this page.
Yes.
F applies to rights acquired as well as rights in the process of being acquired.
Yes.
Do you say that it's disapplied in respect of rights which had been acquired through either limitation or prescription?
Yes, we say you wouldn't be able to acquire rights under section 135 because it would not apply.
No, but if they have been acquired, rights acquired, I understand in relation to in the process of being acquired.
Yes.
I just want to be clear.
Yes.
If somebody had actually acquired a right by prescription,
Yes. The only way a right can be acquired by prescription.
do you say, did section 159 effectively take away rights that had been acquired?
So the reference to prescription in 28(1)(f) is only to sections 135 and 137. 130, the one about easements, 138. Prescription is a reference to those two particular provisions.
So it's not, I'm sorry, I thought you said a moment ago that we had to also take account of prescription under the common law.
Yes, which I accept does continue to operate. I'll explain that. And that's why there is a different part of F which refers to...
Oh, I see. So the only prescription, because it's only rights acquired under written law that are protected or affected, you say we're only concerned with statutory prescription.
Yes.
Is that it?
Well, there is no common law doctrine of prescription. There's only adverse possession as it works in relation to unregistered and registered land.
Right.
In 28(1)(f), the words relating ... acquired by ... prescription are a reference to the prescription regime in this ordinance. That prescription regime, we say, does not apply, and therefore 28(1)(f) cannot be engaged to that extent. However, 28(1)(f) also extends to rights acquired or in the process of being acquired by virtue of any written law relating to the limitation of actions. So if you can otherwise acquire by adverse possession ownership that way, you would accept that 28(1)(f) is engaged. I think it would be most useful, I think, to turn to section 159.
Yep.
On page 459. As my learned friend has said, it's common ground that affects should be read as shall prejudice, which we say means negatively affect, in essence. Section 159 and section 160 must be read together, and in our submission, their dual purpose is to do two things. One is to displace the common law and statutory presumption against this ordinance binding the Crown, and two is to specify the extent to which this ordinance binds the Crown. The common law presumption to which I've referred is the well-known presumption of Crown immunity. I say statutory presumption because that principle is codified in the Interpretation Act, the Interpretation Ordinance in St Helena. I won't take you to it, but it's at page 384 of the bundle, section 43. So the default position without sections 159 and 160 is that nothing in this ordinance would bind the Crown. The purpose of those provisions is the legislature has said, we are happy for this provision, for this ordinance to bind the Crown, but only to this extent, only on this basis. And the basis the legislature picked was that nothing in the ordinance would prejudice any of the interests, rights, powers, and privileges conferred on the Crown of the government under the law. Your lordships and ladyship will note that the wording of section 159 is very broad. Rights, interests, powers, and privileges. It's far broader than the savings clause you often see, which only refers to rights, which gives rise to difficult questions of how far a right is to extend. And this provision expressly forecloses any such debate by using the broadest possible language: interests, rights, powers, and privileges. And in my submission, there's no reason to read that down. It's a legislative choice, and it must be respected. The question really is whether or not the title that the Crown has acquired under section 112 is an interest, right, power, or privilege within the meaning of this section, and then if it is, whether it would be prejudiced by the application of the prescription provisions in Part 9. So with that, I will turn to section 112 and why it falls within section 159. For the moment, I'm going to proceed on the assumption that the Court of Appeal made that section 112 was the source of the Crown's title to this land. My learned friend wants to disturb that assumption. I will come to that under issue 2. But for the moment, I'll adopt the same assumption.
Sorry, can you just take me back to your argument as to the comparison between the position with and without the Act?
Yes. So,
What was your exact argument there when we're looking at, for example, section 28?
yes. So in section 159, nothing in this ordinance shall prejudice.
Yeah.
If the thing which it is said is prejudicing the Crown title would otherwise bind the Crown title, then it is not this ordinance that is prejudicing it. The example of a lease is a good one. The Crown can, at common law, of course, grant a lease over property that it holds. That lease would be binding at common law. That lease under this scheme is registered and is independently given effect. But this ordinance is not prejudicing the Crown's title because that interest, that lease, would otherwise be binding on the Crown's title. It's not prejudiced by virtue of this ordinance. So the question...
Right, so the position of common law...
Or the position apart from this ordinance.
Yes.
Precise.
On adverse possession and prescription,
Yes.
what do you precisely say that was?
Yes. There are two possibilities. The board doesn't have to decide which one is correct because they were both more favourable than the position under the ordinance. One possibility is you could not acquire Crown land by adverse possession. It was not possible. The second possibility is the Limitation Act regime applies and you are given 30 years. The Crown has 30 years to make an application, to bring a claim to recover possession. And can I explain how that makes its way into St Helena law? If you can turn, please, to page 349. This is the English law application ordinance, which hopefully resolves quite a few of the difficult questions which arise about the reception of English law into various overseas territories. And I can take you through the provisions, but the summary of it is that English common law and English statute applies in St Helena, subject to any modifications necessary to make it suitable for local circumstances, and subject to the local legislature having made contrary provision. You can see on page 350, adopted English law is defined as the common law of England, including the rules of equity. And then over the page, also the Acts of Parliament in force in England at the time of commencement. I'll come back to the timing point. That law is applied by section 3, and then section 4 sets out the circumstances in which it's not applied, broadly speaking, when it's
So one option is a parallel to English law, basically.
Yes, so what we
on
say...
the limitation regime.
Yes, so we say the Limitation Act provisions in both the 1939 Act and the 1980 Act, which are materially identical, they give the Crown 30 years in respect of Crown land and 60 years in respect of foreshore, but they give the citizen 15 years.
No, this is a 2005
Yes,
ordinance.
yes,
The ordinance about land law we're concerned with dates from 1980.
yes. That, for
So
reasons I
I
don't...
suppose there must have been an equivalent.
For reasons I don't entirely understand, an English law application ordinance appears every 2 decades or so in much the same terms.
Yes.
And the one that appeared in 1970 is on page 345 of the bundle.
Right. So if that's the one that was in force at the time of the 1980 ordinance, then the comparison would be with the English law incorporated then.
Yes.
I suppose would have been the 1939 Limitation
Yes.
Act.
There's no material difference between the two about adverse possession rules as they apply to the Crown.
Yeah.
I regret that the Limitation Acts aren't in the bundle, but I can give you the references. In the 1939 Act, it's sections 4.1 and section 16. 4.1 is a 30-year limitation period for the Crown, and 16 is the provision which says that the title is extinguished at the end of that 30-year period.
Yeah.
And the equivalents for 1980, for the 1980 Act, are section 15.7 and section 17, read together with part 2 of Schedule 1.
So that's one possibility. What was the other possibility?
The other possibility is that there was no adverse possession regime. So the question of whether the English position applies depends on it being suitable to the circumstances of St Helena, and one can have various arguments about whether or not it is. But my point is, the board needn't trouble themselves with that, because either way, the position was more favourable than the Registered Land Ordinance.
There's no possibility of sort of civilian or Roman law being applied.
Not unless it formed part of English common law.
Right.
And in my submission, the only adverse possession regime is the one by limitation. I should say, I have not been able to identify any limitation ordinance that has ever been enacted in Helena. Having worked through all of the ordinances, certainly up to 1970, 1980, I couldn't find any, and my instructor is nowhere of any either. Could I take your lordships and ladyship back to section 159? It's page 459. The question we've been dealing with is whether the Crown's title is prejudiced. And in my submission, this is the plainest example of prejudice because it is extinguished. At the end of 15 years, the Crown's title is extinguished. Even during the 15-year period, the Crown's title is prejudiced because it is now subject to an infirmity. I showed you the overriding interest provision, which makes even partially completed 15-year period an overriding interest. So it does not matter if you ask the question at the end of the 15-year period, or during the 15-year period, the prescription provisions prejudice Crown's title. That's the first question, the prejudice question, that your lordships and ladyship would need to be satisfied of for Section 159 to be engaged. The other one is that the Crown's title to the land is relevantly an interest, right, power, or privilege within the scope of Section 159. In my submission, title to land is plainly an interest in land and is plainly a right, or more accurately, a bundle of rights in relation to that land. My learned friend takes a number of points about why this sort of interest doesn't fall within Section 159. On his feet, he defaulted to saying that private law ownership doesn't fall within Section 159, but didn't say a lot about why it doesn't fall within interests or rights. In his written case, the focus is very much on, he says Section 159 is to be construed as referring to ongoing interests, rights, powers, or privileges. And in my submission, there are three flaws with that submission. The first and most obvious is that there's no reference to anything of the sort in the text of Section 159. There are two conditions in the section. One relates to the identity of the beneficiary, the Crown or the government, and one relates to its source. It is conferred by another written law. There is nothing about duration, nothing about subsistence, nothing about it ongoing. And indeed, if the legislature wished to say something like that, it could have said it, as it did elsewhere. Section 28(1), for example, refers to interests that for the time being subsist. The wording was open. The second flaw, in my learned friend's submission, is if what he means is that the interest or power must itself still be in existence, obviously we would accept that. An act that's been repealed obviously doesn't qualify as one that confers a right, confers a power. But that doesn't seem to be what he means. He seems to mean that the statutory conferral must be ongoing in some sense. And that's a concept which makes some sense when one talks about things like the powers in the Forestry Ordinance, which confer a continuing power on the Chief Forestry Officer to enter on certain land. One could describe that as an ongoing power. So it has some sort of sense there. But the difficulty is that it makes a mockery of the word interests in Section 159. Because all interests, by their nature, are conferred once and then subsist by operation of the general law. An interest conferred by a grant or by a deed is conferred by the grant or by the deed and then subsists by the operation of the general law. There's no ongoing conferral there. And so if Section 159 were construed as requiring some sort of ongoing conferral, the word interest would be deprived of all meaning. That, my submission, is a powerful indicator that something has gone wrong.
Well, I think the point is that what was given to the Crown under Section 112 was a sort of snapshot of what, however much it was, of the East India Company's
Yes.
land, subject to whatever encumbrances then existed in the land. And that's what they got, but there was nothing there to preclude them from dealing with the land in any way. But you I think, agree with that, except the one thing that is precluded is them losing it by prescription under this ordinance.
Under this ordinance, by virtue of this savings clause. And as I say, I will come back to what has been transferred under Section 112, but for the moment I'm assuming that it was ownership of this parcel of land, which is the assumption that was made in the courts below.
And I think you accepted that nobody can acquire an easement. Is that right? Over Crown land either, if it was vested in the Crown under Section 112. Is that right? Section 138. Sorry, maybe I didn't. Maybe that wasn't the question I put to you.
No. I apologise, my lord. I was thinking it over that. I would agree, subject to this condition. I would have to check what the position about the acquisition of easements by prescription is, but for this ordinance, i.e., what the position is at common law. I don't have that to hand. But if this ordinance is simply replicating the common law rules, then I wouldn't say the ordinance prejudices the Crown title.
So it would be a question of prejudice. That's what it would turn on. That's what you'd be seeking to work out, what the position was
Yes.
without this Land Registration Act.
Exactly. If the position, but for the Registered Land Ordinance, is that you cannot acquire an easement by prescription, I doubt that is the position, but as we take that as an example, if the position is that you cannot acquire an easement by prescription, and the Registered Land Ordinance makes it so that you can acquire an easement by prescription over Crown land, the Registered Land Ordinance operates to prejudice the Crown's title. My learned friend's reading of interests, if he really means some sort of ongoing conferral, reduces the word interests to almost nothing. I think the only category he has identified that would fall within it is interests in land that by statute are made inalienable. And he gave the board some examples of that. I really have two responses to that. One is that in my submission, it's not a good example, because an interest that is rendered inalienable by statute is not an ongoing conferral of title. It's rather a conferral of title coupled with either an incapacity or a prohibition on disposing of that title. In my submission, the example doesn't work. But even if the example does work, those sorts of provisions are so rare that it cannot have been what the Legislative Council had in mind when they enacted the word interests. And it is striking that my learned friend has not identified a single example of a St Helena law which confers an inalienable interest in land on the Crown that he would say is engaged.
So there are no sort of public lands held in public trust or something?
I certainly haven't identified any. I can't claim to have read the entire St Helena statute book, but my learned friend has identified examples from various jurisdictions, including an act about Hampstead Heath, but none from St Helena. The final point here is that if you read interests in this way, if you read interests in a way that excludes title to land, it has a peculiar result, because it means that lesser powers, powers to enter onto land, powers to control the use of land, are saved by Section 159. But title to land, which is the greatest collection of powers in relation to that land known to the common law, is not preserved. A lesser power is, a greater interest isn't, which in my submission is an odd result and not one the legislature should be taken to have intended. My learned friend gave various examples of statutory provisions that he said Section 159 was directed to, things like the Forestry Ordinance, the Airport Development Ordinance. The difficulty with that, I don't dissent from the proposition that they would fall under Section 159. The Airport Development Ordinance contains a power for the governor to, oversimplifying, to designate a particular area of land which will eventually be turned into an airport. I don't dissent from the proposition that would be caught by Section 159, but in my submission, it cannot be said that this was the sort of power they had in mind, because it would be caught by Section 28, the overriding interest provision. If I can take you back to that, it's on page 420. You will see that Section 28(1)(c) refers to rights of compulsory acquisition, resumption, entry, search, user, or limitation of user conferred by any written law. that overriding interest captures all of the statutory powers my learned friends identified. It captures the Land Acquisition Ordinance, which he's pointed to. It captures the Forestry Ordinance. It captures the Airport Development Ordinance.
Where's overriding interest defined for this purpose?
In Section 28.
No, defined.
Not
Is there a definition of overriding interest?
One moment. There's not. I'm not sure it's actually used as a term other than in the heading of Section 28, but certainly it's a reference to Section 28.
Okay, so it's just a label for these things.
I mean, it is used in Section 28, the following overriding interests.
Yeah, okay.
But
So it's cross-referred to in 23(1)(b), which doesn't use the phrase, but just refers to rights and interests as are declared by Section 28 not to require noting on the register. So an overriding interest is one that is an encumbrance on the absolute title of registered land, even though it's not noted on the register.
Precisely. And what my friend says is, well, you have the Airport Development Ordinance, the Land Acquisition Ordinance. These powers would be defeated without the savings clause in Section 159. And my point is, well, that submission doesn't work because the overriding interest provision makes provision for them. So Section 159, whatever it was directed at, is not that narrow. Another point my learned friend made was about Section 121. And this provision appears on page 449. And this is the provision which essentially says that if you become entitled to a parcel of land under a statute or under a judgment, you can ask the registrar, and the registrar will register you as the proprietor. And the submission appeared to be to the effect that, well, conveyances of title by statute are covered by Section 121, and so they don't fall within Section 159. But in my submission, that simply doesn't follow. Section 121 is essentially a direction to the registrar to register any person, including the Crown, where they have become entitled to any land under effectively any written law. But just because a statutory conveyance would fall within its terms does not mean that it must not or should not fall within the terms of Section 159. That simply doesn't follow. A statutory conveyance of title to land is apt to fall within Section 159 as an interest conferred on the Crown by another written law, and Section 121 doesn't change that.
But if there was a judgment of the court
Yes.
ordering that the Crown must transfer some land to another person,
Yes.
would the registrar have to register that other person as the proprietor?
Yes. Because but for the ordinance, that land would pass out of Crown ownership. The ordinance is not prejudicing the Crown land in that example, it's the court order.
When one thinks about interests, rights, powers and privileges conferred on the Crown or the government by legislation, which might be affected by this ordinance, the things that occur to me are things like powers of compulsory purchase,
Yes.
planning powers, all the panoply of powers and rights given to the government or the Crown in relation to land by legislation.
Yes.
And undoubtedly, Section 159 would have the effect that the government's legislative powers and rights and so forth of that kind are not affected.
Yes. Yes.
You're reading it as also extending to rights of ownership, which are vested in the Crown by statute. Yeah. And clearly, one could read the language in the sense that I was suggesting, rather than read it as dealing with statutory vesting of property. In 1834, depending on what you think the purpose of Section 159 actually is.
The two examples my Lord Reed gave, just to take you back to the overriding interest provision on page 420.
And obviously there are lots of others. I mean, there are powers of entry over land,
Yes.
Of statutory undertakers, for example. One could write a book about all the powers that...
I entirely accept. Certainly the three examples my Lordship has given appear in Section 28. It refers to rights of land acquisition, which I think was your first example, in 28.1c, rights of compulsory acquisition. It refers to rights of entry further along in 28.1c, and it refers to rights of user or limitation of user, which I believe was the third example, which would include, for example, planning permission and things like that.
Yes.
I don't dissent from the proposition, as I say, that those things would be caught by Section 159, but it cannot have been. You can't say that Section 159 is confined to them, because that's what Parliament had in mind. Because
how do you deal with the on the face of it, the purposive absurdities that would absurdities that would accrue if you were distinguishing acquisition of title by the Crown by statute and by non-statute? It would seem on the face of it an odd distinction.
The distinction between title conferred by a statute and title not conferred by a statute is baked into Section 159. One can't interpret one's way around that.
Well, that's...
No, but my point...
So that's putting the cart before the horse.
Can I put it to you this way? If one was to apply that interpretation that you're putting forward, it would seem to produce an absurdity. And the absurdity is that you would have a different regime for prescription as against the Crown, depending on whether the Crown acquired their title by statute or not.
Yes.
And on the face of it, there seems no rationale for that distinction. I don't think you can answer by saying, well, that's not what the statute says, unless that is your answer, that we're just forced into an absurdity.
Well, my answer is that if the absurdity is having to distinguish between things that are statutory or non-statutory, that's the single criterion in Section 159. Right? But Parliament, the Legislative Council, could have chosen to protect all rights, or they could have chosen to protect rights in certain things, rights with a certain subject matter. What they chose was to identify the type of right, etc., that was saved by reference to its source, by the words conferred by any other written law.
But isn't that usually, because you gave the argument for, well, wouldn't it be crazy that some lesser rights to control the use of land are protected, but not the ownership of land? But I don't necessarily accept that, because the reason why statutes confer on the state the power to enter land or the power to restrict the use of land, those powers are conferred for a particular purpose in the public interest, usually, and are controlled by the court to ensure that they're used for the purpose for which those powers were granted. So one can see that in order to protect the public interest, which is pursued by the Crown exercising those sorts of more limited rights and interests and powers, that would be why you would not want this counteract those, cancel them out. But there's no public interest in why the Crown was given this land in the 1833 statute or any other statute. It's not exercising those rights to that land for some public good, like it has to exercise the rights to enter into land or acquire land.
I accept that. I can't dissent from that. If I take you back to 1980, when this ordinance is being enacted, but for these provisions, it would not have applied to any Crown land. What the legislature has taken onto itself in 159 and 160 is to bind the Crown and specify the extent to which they're binding the Crown. And for whatever reason, it is one that is generous to Crown rights, titles, interests, and powers. Possibly one might say very generous. The criterion is whether it was conferred by statute, and the subject matter is broadly identified: interests, rights, powers, and privileges.
Yes, there's no doubt on a literal reading, it's capable of having the meaning that you're arguing for. The only point being made against you is that then makes the operation of legislation in relation to Crown property dependent really on the history of the particular property, how it came to be owned by the Crown, and it's difficult to see that as a rational criterion. Whereas if you give legislation a narrower reading as applying to the various powers and rights and so forth given to the Crown in relation to land of the kind we've been talking about, then one can see a rational purpose for the provision to operate in the public interest by effectively disapplying the Act insofar as it would conflict with planning legislation, for example.
The difficulty with respect is that my learned friend certainly hasn't identified any purposive reading of 159 that doesn't undermine the word interests or remove almost all content from it.
Yeah.
I certainly can't think of any examples of the type of power my Lord Reid has in mind where the statute confers an interest.
I think it would be more an interpretation of written law. What I think you're putting forward is effectively a literal interpretation that any written law that confers an interest on the Crown
Yes.
counts. What I think is being suggested by Lord Reid is you can't read that literally, that you have to actually exclude from written law that written law that confers the rights of ownership in the first place on the Crown, because if you don't do that, you end up with on the face of it, a very odd system that would differentiate between how the Crown acquired the property in the first place. And that doesn't seem relevant to the whole law on prescription.
Yes. I'll answer the question, but to flag that points never been taken against me or against us below that written law is to be construed as excluding the section 112. That's never been put against us. But the answer is written law, as it appears in section 159, takes its meaning from the interpretation ordinance, which defines written law. You'll find that on page 374 in extremely broad terms.
I'm sorry, what the page was?
374.
374, thank you.
That's the first answer. The second answer in my submission is that it's not feasible to construe written...
This is just a general interpretation act.
Yes.
Yeah.
And I accept, of course, it's subject to contrary intention, as all interpretation acts are, which is why I have my second point, which is that in my submission it's not possible to define with a sufficient level of certainty the line that is being postulated between written laws that are caught by section 159 and written laws that are not.
Yep.
My learned friend...
But you would accept that your analysis may well produce absurdity?
I wouldn't accept that it's absurdity. I would say whether or not one considers it absurd, the reason your lordship is suggesting it's absurd is because one has to distinguish between statutory and non-statutory. That is clear as day on the face of section 159. That in itself cannot amount to an absurdity when that is the criterion Parliament has, the Legislative Council has selected. I would understand and accept the point if I were inviting the board to read in something which turned on that distinction. Would be a very good reason not to adopt that distinction. But that is the one thing we can all agree on, is that section 159 does turn on whether something is or is not conferred under a written law. My learned friend made a lot of points about comparative legislation. Can I deal with those, please? As I said to my Lord Snowden at the outset, the Attorney General accepts that but for sections 159 and 160, Crown land is subject to the prescription regime in Part 9. And it's necessary to be careful here, because if that question were before the
I
board...
thought you said at the beginning that the presumption was it doesn't bind Crown land and that 159 and 160 are a limited carve-out to that.
That's a fair point, my lady. Can I make it more precise like this? If the ordinance applied to the Crown and the savings didn't exist in section 159, if there was no question about Crown application, I would not be looking at section 135 and saying, properly construed, that doesn't apply to Crown land. And that's important, that distinction, because the Turks and Caicos legislation, for example, that my friend took you to, it specifies in the equivalent of section 135, except not Crown land. It has an express exclusion. So if the argument here was, does the prescription regime in Part 9, properly construed, apply to Crown land, I can well understand that the board would be interested and guided by what other jurisdictions have done. That Turks and Caicos expressly carved it out suggests that it's not expressly carved out or not intended to be carved out in this ordinance. But that's not the question that's in issue. The question is the application of section 159 of the Registered Land Ordinance by reference to section 120 of the St Helena Act. And my friend has not suggested that there is any equivalent to section 112 of the St Helena Act in any of these other jurisdictions. It simply doesn't tell the board very much that in Turks and Caicos, Crown land has been expressly excluded in the equivalent of section 135. My learned friend made a number of points about the arbitrary and capricious effects that our case would have. And he took your lordships to the Court of Appeal decision in Best and submitted, well, those are the types of capricious and arbitrary effects that we shouldn't impute to the legislature. I've made my submissions about any absurdity arising as a result of the enacted statutory criterion. The point I want to make is, in my submission, Best is a far cry from what is before the board today. And if I can take you, please, to page 1088. This is in the judgment of Lady Justice Arden. And my learned friend, paragraph, 1089, the following page. These are the subparagraphs of paragraph 108 of Her Ladyship's judgment. And my learned friend asked you to read subparagraph 4, the first 4 lines. Could I please ask you to read the rest of subparagraph 4?
Yes.
My point here is, these were truly absurd results. A distinction would be drawn between someone who adversely possesses land by fencing it off who wouldn't be committing a criminal offence and therefore could claim adverse possession, and someone who fences it off and moves in, who couldn't. Or a distinction would be drawn between adverse possession of the garden versus the main building, or between farmland and residential property. And Lady Justice Arden, she expressly says these results result in a piecemeal law of adverse possession bordering on the absurd. Lord Justice Sales, as he then was, makes similar points in the section of the judgment that my learned friend took you to.
That's because there would be no criminal offence committed by just fencing it off but not living in it.
That's my understanding, yes. Equally, occupying the garden, I believe, wouldn't have been a criminal offence, but occupying the building would have. Lord Justice Sales sets out similar absurdities in paragraphs 76 onwards. I won't take you there, but just to make that point. So in my submission, there really is no analogy between the sort of case that was being dealt with in Best and the sort of case we have here. And then finally on section 112, my learned friend made the point a number of times about paucity of records, the fact that this criterion would be unworkable. In my submission, that's simply not so. In 1834, the year after the St Helena Act was enacted, and the year in which it took effect, Crown Commissioners of Inquiry were sent out to St Helena. They produced 2 reports, and the board was shown an extract, which we have in the bundle. They conducted what I understand is known as a cadastral survey, and produced a thorough report about the state of affairs on St Helena. That report, at least, would identify every piece of land that the Crown acquired by virtue of section 112. Because if it acquired it any later, it couldn't have been acquired by section 112. It must have been purchased or acquired by some other statute.
But what do you mean by acquired, then?
From the East India Company.
Yes, I understand that. But suppose you've got a cadastral map and it shows this bit is Crown land, this bit is owned by Mr. So-and-so, this bit is owned by Miss So-and-so. What of that land was conferred on the Crown by section 112?
Everything in that survey, marked as Crown land, must have been vested by section 112.
Sorry, are you saying that St Helena was mapped in 1834, and all land, there's a map showing which bits of the land were owned by the East India Company and acquired pursuant to section 112, and those bits which were not, such that any dispute can be easily resolved in a straightforward way?
As I understand it, there's a cadastral survey which would indicate...
Sorry, a what?
Cadastral survey, I understand it's a form of land survey.
Yeah.
I'm told all Crown land was surveyed. My point is this: if something is shown as Crown land in 1834,
Right.
it necessarily must have been acquired by virtue of the 1833 Act. This is only a small part of a submission, which is to say that we don't accept that there's a paucity of records and that it is unworkable. Long before the 1980 Act, St Helena has had a registration by deed. That is not a title by registration, but a registration of title system, requiring deeds conveying land, for example, to be registered. And I'm told there are shelves of these in the archives, registered deeds. We don't accept that there is a paucity of records, which makes it unworkable. The 1834 survey is simply the example that I can give you with.
But suppose in 1860
Yes,
they sold that land,
yes.
how does section... So it's now owned by somebody else. That somebody else is not protected by section 159.
That's right.
159 only protects land that was conferred on the Crown by section 112 and has remained in the continuous ownership of the Crown since that date.
That's right.
So if it was sold but bought back, then it wouldn't be protected.
That's right.
And was all the land that was acquired freehold land?
We don't know. I will come back to that on the section 112 point about what was transferred under section 112, if I may. I'm not in a position to answer that.
Because I think all your submissions so far have been on the assumption that the land that was acquired is freehold land.
Yes.
And that the interest in land is a absolute title.
Yes.
Because if I understand your argument, if the East India Company had a lease, which the Crown acquired, I appreciate it would have to be quite a long lease. If the Crown had not registered it, then the effect of the Land Registration Act would be to allow the freehold owner to sell the land free of the lease.
I'm not sure the example works, my lord, because the East India Company wouldn't have had a lease. It was the...
And that's what I asked, whether the East India Company, whether what was transferred pursuant to section 112
Yes.
from the East India Company to the Crown
Yes.
was purely freehold land, or whether there
Yes.
was some leases in it as well.
Yes. So, in a nutshell, that is an interesting question of construction of section 112. For reasons I will come to very shortly, it is one the board should not decide on this appeal. I don't have an answer to you because
Except, why is it interesting? I would have thought on your construction of the word interests, it's a bit of a no-brainer.
my construction on,
Well, you say interests
yes.
is as wide as it could be.
Sorry, the question the board should not determine is the question of how section 112 is to be construed and what exactly was transferred. Freehold with the lease, freehold subject to the lease, freehold without the lease, that question. The assumption on which the courts below proceeded and on which I have proceeded and on which I will invite your lordships and ladyship to proceed is that section 112 transferred freehold, absolute ownership to this parcel of land. And the question for the board is whether that engages section 159.
Yes, but I sort of understand that, I think, but your argument, as I understand it, which is that interest is as wide an expression as it could be.
Yes.
Therefore, you say it must include freehold,
Yes.
freehold title to land, which
Yes.
thereafter can't be prejudiced by being lost through adverse possession.
Yes.
And I was just taking the next logical question, which
Yes.
is, was any of the land acquired by the Crown in 1833 from the East India Company rented from somebody else? Because if so, the Crown would have acquired an interest, i.e. the leasehold interest, and on the face of it could say, well, hang on a second, we, the Crown, shouldn't be prejudiced by the ability of the freehold owner, who may have registered the land, to transfer it free of our unregistered leasehold interest. It's that sort of question.
If I assume that that factual scenario existed and the East India Company had a lease from someone else that was transferred to the Crown, I'm not sure it could factually have existed because there's no one the East India Company would have had a lease from. If anything, the East India Company would have been the lessor. But if I assume that existed and that was...
There were people who owned, we were told, and I think even a superficial perusal of records suggests that there may have been other people who owned private land on St Helena as well as the East India Company. East India Company didn't own all the land.
There were, before 1833, the East India Company owned St Helena, and there were certainly people who had, as I understand it, interests from the East India Company, under grants from the East India Company.
Right, but you're saying that nobody else owned any freehold interest in land.
You're getting mixed up, I think, with sovereignty or lordship and private ownership.
I don't understand there to have been any other owner of freehold in that sense than the East India Company. People may have held freehold held of the East India Company in the way that people hold freehold of the Crown, if we're being strict about the doctrine of tenures. Doctrine of Estates.
Okay.
I will come back to that. I don't mean to be evasive. I'm not trying to be evasive. The reason for these difficulties is there are difficult questions of construction about Section 112. They require evidence. They weren't ventilated below. I will explain that in a moment and invite the board not to decide that issue. There's a reason why we can't answer these questions, which because it's never been the subject matter of this case. This case has always proceeded on the assumption that title to this land was conferred by Section 112 of the 1833 Act.
But the curiosity is that, again, I mean, I do understand and also understand why my factual hypothetical may have been slightly offbeat, if you like, given the lapse of time. But the question of the status of land and who owned it both in 1833 and who owned it in 1980 on St Helena is something that must have been in the knowledge of the legislature and would be relevant to the interpretation of the statute. It's part of the context and background against which the legislature in St Helena passed the ordinance.
Yes.
And yet we don't seem to have any clear statement of what that context is or was.
No, that's right.
So we're being asked almost to construe a statute in a sort of legislative vacuum, which is sort of not normally the way it goes.
It is a limited vacuum in the sense that the only thing missing was that on the enactment of Section 159 in 1980, there possibly wasn't a clear understanding of what the effect of Section 112 of the St Helena Act was. That's what we are missing in the courtroom here today. In my submission, that is not so significant a vacuum that you shouldn't construe Section 159. As the Court of Appeal said, its words are clear and it does apply to an interest in land. Where the vacuum arises is in respect of Section 112, and it is a significant vacuum. And I will give you examples. If the case was ever brought, if the proceedings were ever brought which required the court to determine what exactly was vested by Section 112, it would be powerful evidence of what the correct construction is, would be what the practice has been for the last 200 years. Powerful evidence would be, did the East India Company retain any property in St Helena after 1833, or did it not? These are all, I don't say that controls the statute, the meaning of the statute, but in the nature of all construction exercises when you're dealing with statutes some 2 centuries old, the practice closer to the date of the statute is often a reliable guide to what the legislature's intention was at the time. And so if the board were to find, for example, that in 1840, everybody was proceeding on the basis that pre-existing proprietary rights had survived the 1833 Act, then I accept that would be evidence, possibly powerful evidence, in support of that reading of the 1833 Act. Equally, if there's evidence from 1840 proceeding on the basis that everything is now owned by the Crown, that would be powerful evidence of that interpretation of Section 112. But because the interpretation of Section 112 has never been an issue in these proceedings, we don't know. It's not in the evidence. The courts below were never asked to consider that question. This is all in response to, on issue 2, my learned friend's attempt to move the goalposts on an assumption I say was made in the courts below. I will take the board through what happened below to make that good in a moment.
But so far as the facts of this case,
Yes.
I understand it, Mr. Francis had a lease from the Crown of 2 of the units.
Yes.
And then he occupied the little unit in between and the unit above.
Yes.
Now, suppose he had had a lease of the 2 units on either side for 5 years, and that lease had expired, and he just continued to occupy those units and also the 2 units of which he had never had a lease. Now, do you say that there's a different answer as to whether he can acquire, if he stays on after the end of his lease, can he acquire absolute title by prescription of those units, but not of the units of which the Crown had an unencumbered freehold? Because of the way that people acquire rights by prescription is quite often by just staying on after whatever colourable right they had has expired and nobody bothers them, and 20 years later they say, well, it's mine now. But is there a difference between the right of prescription acquired if you continue to occupy having had permission to be there, or if you were just a straightforward trespasser from the start?
There's not under the Registered Land Ordinance, and you can see that on page 453, which is section 136 of the ordinance. This sets out what it calls principles of possession, which are used to determine when there has been 15 years of peaceable, open, and uninterrupted possession. And if you see subsection 4...
Can you just give me the page reference again?
453, my lord.
Thank you.
And you can see subsection 4 is directed to the situation where someone overstays their welcome, if I can put it colloquially. And the possession after that point is deemed to be peaceable, open, and uninterrupted.
Right, so you can acquire by staying on after your lease has expired,
Yes.
just as much as by going in as a trespasser.
Yes.
But you say that neither of those can comply, neither of those can happen in relation to Crown land.
That was vested under section 112.
I mean, this may be somewhere in the materials, and apologies if it is, but is section 112 of the 1833 Act the only provision by which land has been vested in the Crown in the history? I mean, has there been anything in between 1833 and 1980?
I'm not in a position to give an answer. I can assist your lordships and ladyship to this extent. There obviously is a Land Acquisition Act. From time to time, I assume that power has been exercised and the Crown has acquired ownership. Probably one of the laws relating to the airport permitted the acquisition of that block of land when it was built. And
the bulk, if you're right, the bulk of land on South Helena was acquired by the Crown pursuant to section 112 in 1833.
I would have thought so, wouldn't I? Yes.
So, and is this right? You say there are no problems with understanding which land was acquired from the Crown, by the Crown in 1833, because we've got a map drawn up in a survey in 1834.
I can't say there will be no problems. I'm doing the best to respond to my friend's assertion from the bar table. There is a paucity of records.
Yeah,
his instructions may be that, my instructions may be are different. There's not much more I can do to assist your lordships with that. My attempt to ground that in the record is one survey which we do have extracts from in the bundle.
I mean, the difficulty is that the argument is that section 159 can't have the effect you say it has, because it would create an unworkable system which would require people to understand whether the land that they claimed to have acquired by adverse possession or otherwise by adverse possession or an easement by adverse possession had been acquired in 1833. And your answer to that is there will be no such problem, or a minimalist problem, therefore Parliament could be assumed to have created that system, whereas the other side is saying there would be a real problem with that system. It's so absurd, unworkable, it cannot have been what Parliament intended. Now, that background as to is something that I, for one, am struggling with, because we're being asked, in a sense, to put ourselves into the position of the legislature and decide what they intended against a factual background which they must be presumed to know, but which we've got no evidential record for in these proceedings. And that's just a very difficult interpretive position to be in, isn't it? I'm not criticising you, I'm just saying it's unsatisfactory.
Yes, if you'll give me 1 moment, my lord. My lord, the submission is that the evidential problem, to the extent it exists, is not one that is so significant that it ought to influence the interpretation of the statute in the way that has been suggested against me. Before 1980, there was a system of registration of deeds by which land was conveyed. It was one of the earliest laws enacted in St Helena. In 1839, as I understand it, is the first instance of a law relating to the registration of deeds, and it existed in various amended forms through to 1980. My instructor tells me there are shelves of those deeds in the archives. There is the cadastral survey from 1834, which was a survey of the entire island. It does identify the block of land with which we are concerned as Crown land. I can't put the submission any higher than that, other than to say that if your lordships and ladyship consider the evidentiary background or the evidentiary vacuum is so significant that the question of construction can't be decided, the proper course is for it to be remitted. This was, of course, a case stated by the land registrar. And if the answer to the question is the court's not in a position to answer the case stated, the proceedings should be remitted and they would go back to a trial on the evidence before the land registrar or possibly before the Supreme Court. And the construction issue could be determined then. Any evidential vacuum shouldn't be used to determine the construction question the other way against the Attorney General. I have been rather dancing around Section 112, so could I address that head on, and then I will come back to Section 31. I referred to it as an interesting question. That was an ill-advised remark. I simply meant to convey that it is objectively a very interesting question about Section 112 and the circumstances which arose in 1833, and I'm in the potentially unenviable position of asking your lordships and ladyship not to determine the question. The difficulty for my learned friend is, the gist of his submission is Section 112 only vested, if I can put it this way, governmental land and not non-governmental land. I'm paraphrasing. The trouble is that was never in dispute. The construction of Section 112 has never been in dispute in these proceedings. There has always been an assumption that the land we are concerned with was vested according to Section 112. The Court of Appeal decided the case on that basis, and I would invite the board to decide the case on that basis. And can I take you at some speed through what happened in the Court of Appeal? The place to begin is page 166. This was a request, a direction, from the Court of Appeal for submissions on a particular issue, the issue being essentially, would Section 112 engage Section 159? The submissions that were put in response to this, if you turn over 2 pages, you will see the Attorney General's submissions at page 168. His position was paragraph 3, there was a vesting by virtue of the Section 112, by virtue of the 1833 Act. Paragraph 5, Section 112 is ultimately the source of title for the land subject to this appeal. And paragraph 8, that is sufficient to engage Section 159. Mr. Francis puts in his submissions. They appear at page 174. And you can see at at paragraph 3, there's a suggestion that the Crown acquired sovereignty over St Helena, and then with this sovereignty, it gained title to the land and various buildings. Paragraph 4 is the suggestion about previous persons in private ownership. It says that title wasn't extinguished. And in paragraph 5, the submission essentially is that the 1833 Act vested land in the Crown, but today, that's not where you look. Today, you look at the Registered Land Ordinance to work out what the Crown owns. That's the gist of the submission. There is no submission here, and your lordships and ladyship will find no trace of submission that, oh no, but this land was of a type which, when Section 112 is properly construed, was not conveyed. The point was never run. Now, the Court of Appeal...
When the Crown applied to register all the land,
Yes.
what do you have to show to the registrar to prove your title?
One moment. The precursor to the Registered Land Ordinance was I believe it was called the Land Adjudication Act, where there was an adjudication procedure throughout St Helena, where effectively parcels were marked and boundaried, claims were recorded, and then it was subject to the possibility of appeal if people disagreed with the conclusions of the adjudicator, they were called. In that process, the Crown effectively filled and signed a form saying that this parcel was Crown land, and that's what occurred in relation to this one. And so it's registered as Crown land.
What sort of time period was that carried out?
It was leading up to the 1980 ordinance.
Yes, I see. I mean, this is in a way a move from a sort of unregistered to registered system, is it?
Yes.
Yeah.
Yes.
So this was for the purpose of making sure that the register on day one was accurate and any fights that there had been were sorted out.
Exactly. So, as I understand it, after this process, there was no unregistered land on St Helena. It's not like the English system where you can still have parcels of unregistered land. In the interest of time, I won't take you to the Court of Appeal transcript, but I'll give you the page references. 255 and 256 are the passages about the 1833 Act. There was a short hearing on limited points, but there were some submissions made about that. The most profitable place to see this is the Court of Appeal's judgment. So page 77, you can see at paragraph 40 of the Court of Appeal's judgment. The respondent argues, in response to a request for further submissions, that no interest in land which could be affected by Section 135 was granted by Section 25. We'll consider this later, but it would appear to be contrary to the way the hearing was conducted in front of the Chief Justice. There's then a reference to 3 paragraphs in the Chief Justice's judgment. In addition to those, I won't take you to them, but can I give you 2 more which make the same point? This is the Chief Justice's judgment at paragraph 113 on page 100 and paragraph 135 on page 105. Those are additional references.
Sorry, give me the first one again.
Sorry,
Page
paragraph...
100, paragraph.
Page 100, paragraph 113. The Court of Appeal says we'll come back to this argument, and they do that at paragraph 47 on the next page. And you can see the submission there is that The respondent argues the effect of section 112 today is not to grant any interest in land, but is only the legal basis for sovereignty. And then the respondent makes the point about there being pre-existing ownership. Paragraph 48, while accepting that the point about private ownership may be correct, my learned friend suggested the Court of Appeal had accepted that, with respect, may be correct, is not an acceptance, it is an assumption. It does not follow, it is irrelevant, because they clearly concluded section 112 did grant an interest in land, indicated by the specific individual properties. And the Court of Appeal repeats this at paragraphs 58. In its concluding paragraph, it says, it follows in our view, accepting the proposition that the Crown did acquire an interest by virtue of the 1833 Act, which was how the matter was argued in front of the Chief Justice, the answer to the posed question is no. So what the Court of Appeal decided was the issue of whether section 112 vested land in the Crown was not open to the respondent because the hearing before the Chief Justice had been conducted on the basis that the interest was vested. And second, in any event, they seem to have rejected a submission that section 112 conferred no interest.
So there could have been two things. You could have said 112 is only to do with sovereignty, it's nothing to do with private ownership.
Yes.
They rejected that. And then there's a question, well, all right, it was some private ownership, but it's certainly not the private ownership of the whole island, to which the Court of Appeal said, well, maybe or maybe not, but it's certainly vested private ownership in this, or it was argued on the basis that it's certainly invested private ownership in this parcel. Is that fair?
I can't entirely accept those. So the first proposition your ladyship put to me was that the argument was put below that section 112 did not vest any property, only sovereignty. The written submissions I took you through from Mr. Francis accepted that it vested some title. And the second proposition your ladyship put to me was the question about whether all property or only some property was transferred. That in my submission does not appear anywhere below. The first suggestion that section 112 has some dividing line in it, which is crucial to this case, appears before the board. It is not to be found below. I've set out in my written case the extract from Baker and the Queen, with which the board will be familiar about the board's practice in not allowing new points to be taken on appeal. Lord Diplock gives two circumstances where it may be permitted. One is where the views of the lower courts aren't likely to be material. Respectfully, that can't apply here. This is one of the, if not the foundational statute of St Helena, and I think the discussion in the courtroom today has indicated the board certainly would have been in a better position if these issues had been raised below and the courts of St Helena had dealt with them. But the second of Lord Diplock's conditions is the more important. He makes the point that the court shouldn't entertain new points where they could have been met by evidence below. I have already made my submission that if the construction of section 112 were truly an issue, evidence of the position over the last 200 years would be highly relevant. Evidence of what the position was before 1833 would be highly relevant. The context in which the Act was enacted would be highly relevant. None of this is before the board. And the reason for that was that it wasn't an issue below. But the point is worse for my learned friend for this reason. Even if the board were to ignore all that and were to decide this question of whether section 112 has a dividing line between governmental and non-governmental property, that would be entirely in the abstract and the hypothetical, because there is a factual question that is live as to whether this was governmental or non-governmental property in 1833. My learned friend refers to a map from the National Archives suggesting that it was commercial land. We, simply to meet that suggestion, have put in evidence, it's referred to in a footnote, suggesting that actually it was the governor's residence, which my friend accepts is a governmental function. I'm not asking the board to rule on that. I'm making the point that this evidence was not put below. It's not uncontroverted evidence. When my friend first suggested raising it, We asked that they put in a Latin Marshall application. That hasn't been pursued for obvious reasons. It would be doomed to fail. In the absence of that factual point having been determined, this is a question of statutory construction that would be determined in the abstract without regard to any particular plot of land.
So you say we should assume that this parcel of land was vested in terms of private ownership in the Crown by Section 112, and it has stayed in Crown ownership since then.
Yes. The board can assume that. The board should not be troubled by that assumption, because Lord Diplock goes on to say there are plenty of decisions of the Privy Council where the board assumes things which don't form part of the binding ratio that future courts have to follow. It's simply a consequence of this board's practice not to allow new points to be taken like that. Finally, on this point, can I take you to Section 112? And simply, I want to make 3 points which indicate that the complexity of the question is another reason why the board should not determine it. If I can ask you to go to the preamble, it's at page 666, preamble of the 1833 Act. The first point I want to make is that the preamble says a number of things about what the Act does with respect to the East India Company, but in both respects, it cuts out St Helena. So partway down through page 666, it refers to the East India Company being entitled to claim lordship of the island of St Helena under grants from the Crown. Over the page, St Helena is mentioned. So about a third of the way down page 667, your lordships and ladyship will see on the right-hand side, be it therefore enacted. Approximately a third of the way down. That is the beginning of the Act. That is the end of the preamble.
Yep.
And then if you follow along a little bit further, it says, in this present Parliament assembled, and by the authority of the same, that from, capitalized T, that from. That is the beginning of Section 1. And the first section here...
That from and after the 22nd day?
Yes, exactly. That's Section 1. And this first section here does two things. British territories in India to remain under the government of the company until 1854, and the real and personal property of the company to remain with the company but to be held in trust for the Crown. It does those two things, but in both respects, St Helena is excluded. So you will see about 5 lines down, except the island of St Helena, and then 5 lines further, except the island of St Helena. The point simply is this. This Act does a great deal of things. The only thing that is relevant to St Helena is Section 112. It's not part of some broader scheme. For the rest of the East India Company's territories in India, there was a scheme set up whereby they held property in trust for the Crown. In 1858, it was reverted to the Crown, and then in 1874, the company was dissolved. But St Helena is only dealt with in Section 112. 2 points about Section 112. The first is the submission that it just vests sovereignty, in my submission, is incorrect. St Helena has been under the sovereignty of the Crown since the 1600s, when the first charter by Oliver Cromwell was granted. 1657. I won't take you there, but the history of St Helena is mentioned in the preamble to the Constitution, page 551. And your lordships and ladyships saw in the preamble that St Helena was under grant from the Crown. So there has always been sovereignty of St Helena. The idea that Section 112 does just that, in my view, is a non-starter. In my submission, is a non-starter. The second point, or third point, sorry, is that Section 112 has 3 limbs. There is the limb vesting the island of St Helena. There is the limb vesting all forts, factories, public edifices, and hereditaments whatsoever. And there is the limb vesting all stores and property thereon, fit or used for the service of the government thereof. The first 2 are in any view concerned with realty, real property. The third is concerned with personal property. My learned friend's chief argument is that fit or used for the service of the government thereof is to be read back as applying to the second limb. In my submission, A, the structure of the section, but more importantly, B, the words any hereditaments, and hereditaments whatsoever are positively inconsistent with that. I'm not taking a position on the construction, I'm just illustrating the difficulties and reassuring your lordships and your ladyship that the arguments can be met. Finally, to finish off this point, one possibility my learned friend hasn't averted to is the possibility that Section 112, rather than operating on the rights held by the residents of St Helena, the citizens, is in fact operating on whatever rights the East India Company had as Lord of St Helena, in the sense that under English land law, persons hold estates granted from the Crown. They hold them of the Crown. And there are estates, or there would have been estates in St Helena held of the East India Company. And one possible construction is that this section simply replaces the East India Company as the paramount feudal lord with the Crown as the paramount feudal lord. As I say, I don't take a position. My objective here is to persuade the board that this is, although interesting, a very difficult question that would depend on the evidence that the board should not decide and which hasn't been run below. I don't have very long to go. I want to say a few things about Section 31 of the Constitution, which is the alternative basis on which we say Section 159 is engaged. If I can take you to it.
Before you do,
Yes.
Mr. Happy's base, there was a troubling proposition raised by the other side that literally construed Section 112 would suggest that all the island of St Helena was vested in the Crown, or on your view of it, by reversion to the Crown from the EIC. This last point you made, although you don't wish to put it forward as a conclusive argument, ought it to be considered in that context as to whether or not Section 112, the brigade is operating so as to revert to the Crown any rights held of the East India Company.
My submission is, my lord, that it's one possible construction of Section 112. The board can't with confidence conclude that it's the right one without further evidence. In particular, you can well imagine that it would be highly relevant to know what the state of landholding on St Helena was before the 1833 Act and what the state of it was treated as being after. If it turns out that in 1834, everybody assumes that their interests have been cancelled or expropriated, then that would be highly relevant. If it turns out they've been expropriated and re-granted, that would be highly relevant. If everybody proceeded on the basis that they had continued through, that would be highly relevant. But we just don't know. And I don't say that it controls the meaning of the statute, but simply that someone who in the late 1830s took a view as to what the statute means was obviously a lot closer to the context in which the 1833 statute was enacted and is more likely to have understood what was intended. That's a proposition I take from the Bloomsbury case in the Supreme Court, which is in the bundle and referenced in my written case. I want to say a few final things about this.
Thank you.
Sorry, thank you, my lord. Section 31, if I can take you to it, it's page 570. This is an independent basis on which we say Section 159 is engaged. The argument is this: if the Registered Land Ordinance prescription provisions apply to Crown land, they permit Crown land to pass out of Crown ownership without any action by the Governor or by the Crown, and that undermines the Governor's power to dispose of interests in the land. It pulls the rug out from under it.
Why? I mean, he still has the power to dispose of land on behalf of the Crown.
It's necessary.
It doesn't say, I mean, are you saying that that has to apply to every bit of land on St Helena, and that's the only way, you're saying that's the only way that land can be disposed of by the Crown or can pass out of the ownership of the Crown on St Helena?
No. There was a submission made below that Section 31 is the exclusive code of ways that land can pass out of Crown ownership. Don't repeat that submission.
Okay.
The submission is the power is defeated. And the reason, I mean, my learned friend made, my Lord
What
Lord
power
Snowden,
is defeated?
the power to sell. The power to sell, the power to grant a lease, the power to dispose of interests in the land. My Lord Snowden made the point that, he still has the power in relation to all of the land in St Helena. In my submission, it's necessary to focus on the power in respect to any given block of land, any given parcel of land. And by removing the subject matter of the power has been defeated.
But I don't quite understand what the distinction is between that and what you say you're not saying, which is that Section 31 is the exclusive way in which land can pass out of the ownership of the Crown.
Yes.
So what other ways, apart from prescription or disposal under 31, might you be thinking of?
Prescription is the obvious example.
Yeah.
And I accept that the Legislative Council can expose Crown land to prescription. And it can do so because Section 31 isn't exclusive in that sense.
Because of it says subject to any other law.
That's one of the reasons. But I don't repeat the submission below that it's an exclusive code of the ways in which Crown land can be disposed of. My point is that this is a power conferred on the Governor to dispose of land. And in my submission, if you have a power to dispose of Blackacre, and you find that Blackacre has, by operation of law, without any act of your own, been taken out of your ownership and put in someone else's ownership, that is tantamount to defeating that power by removing its subject matter.
But that would have, on that footing, the prescription would have been done by another law.
Sorry, my lord.
If prescription operates under another law, is the ordinance,
Yes.
the fact that the Governor can no longer dispose or exercise his power on behalf of the Crown to dispose of it, it doesn't infringe Section 31.
This is precisely the point my learned friend takes against me, which focuses on the proviso at the beginning of Section 31, subject to any other law. It doesn't work for this reason. The proviso to Section 31, its effect is to ensure that Section 31 yields to inconsistent laws, if I can put it that way. But the very question before the board today is whether the prescription provisions would prejudice and defeat the power conferred by Section 31. And if they do, Parliament has expressly said that it is not intending to say anything inconsistent with Section 31.
No, hang on. I thought you were running this argument on the basis you've lost on Section 159.
No.
I thought you said this was an independent ground.
It's an independent ground on which we say Section 159 is enlivened, because Section 159 depends on another written law. One is Section 112 of the 1833 Act, and one is Section 31 of the Constitution.
I see.
I'm sorry, I should have made that clear.
So this is another written law
Yes,
relevant to section 159,
precisely,
in addition to 112, or
Precisely.
instead of.
precisely. And it falls within powers in Section 159, because Section 31 confers a power on the Governor, and you can see the heading to the provision, powers to dispose of land. The points put against me are the proviso, and in my submission, you can only conclude that the power is not prejudiced because the proviso permits derogation by assuming that the legislature intended to derogate. But the legislature has told us in Section 159 that they are not intending to derogate from any powers conferred on the Crown. So the board should start from the position that the question is, does the Registered Land Ordinance prejudice the power in Section 31? If it does, The legislature has said that that was not their intention and that shouldn't happen. The second point put against me is the point raised by my Lord, Lord Snowdon, which is, well, the governor still has the power under Section 31. In my submission, it is Section 159 would cease to have any meaningful operation if you could focus on the power in that abstract way rather than the power in respect to a particular parcel of land. To put that another way, prejudicing a power must include removing its subject matter. It can't have been the legislature's intention that you could prejudice a power by removing its subject matter but leaving the form of the power intact. There are two final points on this in response to points that your lordships and ladyship made to my learned friend. The first was that my Lord Snowdon pointed out rightly that Section 26 of the Registered Land Ordinance essentially repeats Section 31. My answer to that is that it's neither here nor there. If Section 31 is prejudiced, equally Section 26 of the Registered Land Ordinance is prejudiced. But the question for the board is whether Section 31, that power, would be prejudiced. The final point on Section 31 is my lady, Lady Rose, raised the prospect of Section 31 essentially identifying who it is that can exercise this power rather than conferring an actual power. And my friend made a similar point with respect to this being a public law power. In my submission, 31 confers a private law power on the governor to sell the land. The governor is a creature of this Constitution. He has no common law existence or common law powers. This is a power conferred on him by this Constitution, and but for Section 31, he wouldn't be able to sell land in St Helena unless His Majesty delegated that to him as a governor in a different way. The other way of thinking about that is that Section 31 is the codification of the royal prerogative to sell property. And if it is the codification of the royal prerogative to sell property, it overtakes any common law power to sell property by virtue of De Keyser's case, among others. My submission is Section 31 does what it says in the heading. It confers a power to dispose land on the governor, and that power would be prejudiced, negatively affected, which is the construction I think we are at ad idem, the parties, that should be given to the word prejudiced in Section 159. It would be negatively affected by prescription applying to Crown land because it would be defeated. You cannot lease out property that has passed out of your ownership. You cannot sell property that has passed out of your ownership other than by your own act.
Now, you're going to have to complete your submissions
Yes.
very quickly
Yes.
to allow Mr. Hitchens time to reply.
Yes, that was what I wanted to say about Section 31. One moment, my lord. Yes, the only closing point I wanted to make was to repeat the point that there is nothing undemocratic in the case that the Attorney General puts. It arises from the democratically elected legislature enacting a particular criterion. It is true that it may have effects that seem unfair by privileging Crown land. That is the legislature's choice. They can change it. And I would only add that it is not unusual for the Crown land to be privileged when it comes to adverse possession, as I pointed out with respect to the position in this jurisdiction for unregistered land. That has a long history of the Crown being privileged when it comes to time periods for adverse possession. Your lordships and ladyship will be aware of the original position, nullum tempus, where time didn't run against the Crown. It now runs, but is longer. My point is, there is nothing undemocratic or unusual about the position which I invite the board to adopt in St Helena. Those are my submissions.
Thank you very much. Yes,
My lords, my lady, I have just 3 brief points in reply. The first is, I think my learned friend said a moment ago that Section 31 created what he described as a private law power. My lords, my lady, I say that Section 31 falls within Part 3 of the Constitution. I say when you look at the other provisions of Part 3, we start at page 567 of the bundle, you get a pretty good sense of the nature of the powers which are being conferred under the Constitution. You'll see paragraph 26(1) establishes the office of governor, requires the governor to follow directions by the Secretary of State. We can then skip section 27, which relates, and 28, forgive me, which relates to a governor's deputy and an acting governor's. But you see at section 29, you have the power of pardon. So the power to grant pardons to those who've committed offence in St Helena. Paragraph 30 relates to the prerogative of mercy and the exercise of that prerogative. Paragraph 31, of course, section 31, forgive me, is of course the power to dispose of land. And then paragraph 32(2) provides that the governor shall have custody of the public seal. And then paragraph 33 of the Constitution, which is the final section in part 3, empowers the governor to create public offices. So I say, by their nature, it's clear that Part 3 exists to create public law powers and not private law powers in the sense that my learned friend suggests. So that's my first point in reply. My second point in reply relates to section 112. Now, my learned friend says this was never before the Court of Appeal. Can I just take you to a couple of extracts in this respect? So first is one that my learned friend did take you to, is page 174 of the bundle. And this was Mr. Francis' submission in advance of the Court of Appeal hearing. You'll see at paragraph 4, it set out that prior to the enactment of the 1833 Act, there was long-established private title holders in St Helena. The title holders' existing claims over the land was not extinguished by the 1833 Act, so that's precisely the argument I was making earlier. In short, it is a fiction that 1833 prescribes Crown land to the extent that all land in St Helena vests in the Crown. So that is, in my submission, precisely the argument that I was advancing before the board earlier. My learned friend made reference to the transcript, but don't think you went to it, so I'll just take you to it if I may. It's at page 255 of the record. And you'll see... 255. 255, my lord, yes. And you'll see at the bottom, the President of the Court of Appeal puts it to Mr. Scott that it was proceeded on the basis that the Act did vest rights over land in the Crown. You'll see that Mr. Scott dissents from that having been his position before the Chief Justice. And then over the page at 256, you'll see the exchange continues, and Mr. Scott says, certainly at the time, it vests factories and buildings for government, but the idea it vested all lands into the Crown in a freehold or a manner which my friends urges is called to, is just not something I have presented the position as being. So Mr. Scott is clear that it is not his position that all land is vested in the Crown. He's clear that there is a distinction between government land and, for example, factories versus all other land, and that private ownership by other title holders is preserved. So I accept that the Court of Appeal, and actually let's look at what the Court of Appeal said as well. It's at page 79. And you'll see at paragraph 47, I know I've taken the board to this extract already. The respondent argues that the effect of section 112 is not to grant any interest in land, but only the basis for sovereignty. That's not quite how the point was put by Mr. Scott. And then at paragraph 48, there's a conclusion that it did vest interest in land into the Crown. And there's no mention of the distinction which Mr. Scott had alluded to in the exchange in reference specifically to government land. So this is, in my submission, something absolutely that was before the Court of Appeal. I accept it's not something that the Court of Appeal dealt with in any great detail, but that is not a reason in my submission why the board should not deal with it today. This is not an issue which requires evidence, as is suggested by my learned friend. This is a straightforward exercise in statutory construction. And there wouldn't be any benefit of further consideration of this matter at first instance in my submission, because it's a matter in dispute between the parties. It's one that requires resolution, and it's one that the board will be in as good a place as any other to deal with today. And it was something that was squarely pleaded in the grounds of appeal as well, when the appeal was lodged before the Privy Council. So we have it raised before the Court of Appeal in writing, we have it raised orally, and we have it being raised in the grounds of appeal before your lordships and your ladyship today. I respectfully submit that on that basis, the board ought to deal with it. The last point I wanted to deal with was the questions concerning the paucity of records in St Helena. There was an exchange between my Lord Snowdon and my learned friend. My learned friend's right. We had identified a single plan. So we had asked for there'd obviously been a search conducted in St Helena for records relevant to this piece of land. Nothing could be found by the public solicitor officer in St Helena. We went to Kew and did a search for any records relevant to this piece of land, and we found a single plan. We brought that to the attention of the Attorney General, who objected to it being placed before your lordships and ladyship, just as my learned friend said. So that hasn't been placed before the board.
Is this the one from about 1821?
It was, my lord, yes. It predated 1834, yes, that's right. We can certainly provide a copy if it would assist, but we haven't placed it before the board because in light of the objection. And then the Attorney General went away and appears to have done a search for anything that could rebut that. And all that was able to be produced was the extract at 1363. Now, if your lordships and your ladyship need to take a view on the availability of records which will determine whether land transferred in 1834 because it was used for and fit for the service of government or otherwise transferred in 1834 and then had been sold by the Crown or not been sold by the Crown subsequently, etc., etc., that background gives you the answer in my submission as to how likely it is that those records will be readily available to proceedings before the land registrar. That's the first point. The second point is the practical implications of that. It's important, I think, for the board to understand that the two sets of lawyers who will be litigating.
So, sorry, is your point that this cadastral plan that we're now being told about was made shortly after this, that was not something that was found easily by the attorney and put before the Chief Justice? Or?
Yes, and it wasn't
yes,
able to be.
You're agreeing with me, or yes, it wasn't?
No, I'm so sorry, my lady. Yes, that is my point,
right.
Which is that my learned friend says, well, there may not be practical difficulties. His instructions are there won't be great practical difficulties in obtaining records, which will determine these issues. My point is they've been unable to acquire those records in this case. The extent of what you have is a single plan from the 1820s that we've been able to identify in Kew, and the records at page 363 of the bundle that you've been taken to. That's it. And that is likely to be reflective of what might be available in other cases if the two-tier system that the Attorney General urges upon you is adopted. So I say you can proceed on the basis, and certainly it's my instructions, that there is a great paucity of records. There's going to be great difficulty in locating and obtaining relevant records, not least because some are held in the National Archives in London and some are held in St Helena. And the point that is linked to that is it is important in my submission for the board to understand the local circumstances in this regard, because I addressed you a moment ago that at the outset on the role of the public solicitor, that is an office, I think, of 3 qualified solicitors dealing with the legal requirements for every member of the population in St Helena. And similarly, the Attorney General's chambers are face very significant resource constraints that have arisen in other cases that I've been involved in. The idea, and sorry, linked to that, all of the records are in paper in St Helena. So the idea...
I don't think the Q records, and I think there are also some in the British Library, I don't think they're searchable online.
They're not, my lord. What you'd have to do is you have to find the catalogue entry, pay a fee for that to be scanned and emailed over to you.
Yeah.
But of course, the catalogue entry won't reveal necessarily whether the document will be any assistance. Yeah. So the practical reality of the Attorney General's chambers or the Public Solicitor's Office doing these searches is going to create a great deal of difficulty and would, in my respectful submission, render the whole scheme entirely unworkable. So those are my 3 points in reply, unless I can assist any further.
Thank you very much.
Mr. Hitchens, a question from me, please. We were told that there had been a cadastral survey which ended up in a registered land system, making it unlikely that there were any longer any parcels of land which are not reflected in a registered title. That is the essence of the Torrens land system. Is that so or is that not so?
My lord, I'm so sorry. I'm slightly struggling with the sound.
Yeah, Sir Anthony was saying that the essence of a Torrens land system based on a cadastral survey of
Yes.
land is that it's exhaustive. All land is surveyed and its ownership is recorded in a public register. And I think he was asking, is that the situation in St Helena?
So my understanding is post-19... Can I just turn my...
Yeah.
It's post-1980. Yes. So post-1980, that is the position, my lord. My instructions, my understanding are that before 1980, that was not the system. There was, and my learned friend's nodding his head. So that's the position, that before 1980, there was not a Torrens land system in place. It was introduced through the 1980 ordinance. There were deeds, obviously, that reflecting transfers before 1980. But my instructions are that many of those deeds have not been retained and have been lost over the years. So it would create great difficulties in my submission.
Before the we were told that before the registration system was put into operation, there was a land adjudication process which worked out who owned what. And one can assume that that process must have identified what land was Crown land so that the governor could then apply to register it, to which I guess you would say, yes, but it doesn't identify whether that land was acquired by the Crown because of Section 112 or from some other time. But I think the cadastral plan we were being told about was a much earlier thing in 1834. But again, whether particular land is owned, has been owned for the whole time or not, we don't think.
It's impossible. I would submit in the vast majority of cases, it will be impossible to determine by references to the records whether or not a piece of land, A, transferred in 1834, and B, whether it's come in and out of possession of the Crown since through private sale. I accept that post-1980 the position is much easier. Can I assist any further?
It looks as though there are no further questions for you. Thank you very much, Mr. Hitchens. Well, this is an unusual and interesting case. We're grateful for the assistance the Council have been able to give us. We'll now consider the advice that we will humbly tender to His Majesty. The Court will adjourn.